Hello, folks. This is a PowerPoint presentation that is designed to familiarize you with the criminal cases that Donald Trump is facing presently, and also two civil cases that are of some consequence. One of them is really quite significant. So I'm going to go through them so you can understand what they're about. There's a lot of people talking about them, and I want to make sure you understand what they are about. And I don't expect you to become constitutional lawyers or criminal lawyers or anything out of this, but I think you'll find it interesting, and I really think you should be able to discuss these matters with your family and friends and understand what they're about. So I don't want you to leave the course without that, and that's what we're going to do here. You have a bunch of documents, indictments, etc. to review. You don't have to memorize or read all those, 100-page indictments, but familiarize yourself with them so that you understand what they're about. Take a look at them. You'll be way ahead of most people in the news media and the public if you simply do that and listen to this presentation. So here we go. Donald Trump is facing numerous lawsuits that could potentially do a couple of things. One, they could influence the outcome of the 2024 presidential race. Depending upon how they go, and they could change his life permanently because the consequences could be incarceration and loss of a tremendous amount of money, or not, or maybe he'll win all of them, and maybe they'll all go away somehow. But there's potentially high stakes for him and for the country. So briefly, there are 4 criminal cases. They are all in different jurisdictions. And in those criminal cases, he is charged, generally speaking, with various types of conspiracy and fraud. I'll show you the details in a minute, but there are 2 of them that are federal cases. One is in federal district court in Florida, and the other is in the federal district court in the District of Columbia in Washington, D.C. So they're in 2 different courthouses. The federal trial courts are called district courts, and there are districts all over the country, and he's in one of the cases is in a Florida district down in South Florida, and the other one is in the District of Columbia. That's because of where the events occurred. They're in the districts where the events occurred. And then there are 2 state cases. One is brought in the state of New York by the Manhattan District Attorney, and the other is in Georgia by the District Attorney of Fulton County, Georgia. There's also something you don't hear much about, but it's very significant. There is a civil fraud suit, because it is possible to be sued civilly for fraud. In this case, it's being brought against him by the Attorney General for the state of New York. And the aim of that case is to put him out of business in the state of New York. This could have very serious financial consequences for him. There's also a civil defamation suit in New York against him in which a journalist by the name of E. Jean Carroll is seeking $10 million in damages for him lying about sexually assaulting her. She had already won a $5 million jury verdict against him for making these statements. And after he lost the case, he repeated them in public, and she sued him again, in essence, enlarged the original suit. And now he's facing more damages for defaming her. So, few key concepts. Again, don't expect you to be a lawyer, but basic terminology. First, when I say jurisdiction is the power of a particular court to hear a case. Sometimes it's about the subject matter of a case, like some cases are supposed to be brought in federal court. Diversity of citizenship, meaning cases where the plaintiff and the defendants are from different states, those are usually brought in federal court. They're supposed to be. And then others are what are called federal question cases, where the law of the case is federal law. But most lawsuits are brought in the states. The vast majority of litigation is, everything else other than diversity and federal question takes place in state courts. So you've got 2 of each here, two state, 2 federal. Then there's also, by jurisdiction, we mean sometimes where did it happen? Geographical jurisdiction. And then there's the question of trial and appellate jurisdiction. We have trial courts for trials, basically, and we have appellate courts to handle appeals. These cases are all presently in the trial courts. Now, why do we have so many courts? Well, we have a thing in our country, we call it judicial federalism, which means that there are federal courts and also state courts. Excuse me. And they are set up to do different things. But sometimes they can handle very similar matters, which is what's happening with the Georgia case and one of the federal cases. State cases can also be transferred from state court to federal court. That's called removal, and we'll talk about that. Civil versus criminal, very important distinction. The penalties in a civil case are basically money, but the penalties in a criminal case can involve incarceration. Also, the burden of proof is very, very different. In a civil case, you just have to prove your case by a preponderance of the evidence, more likely than not. Criminal case, you got to prove that beyond a reasonable doubt, which is a very high standard and much harder to do. Point is, it's a lot easier for a plaintiff suing Trump to win a civil case against him than it is to win a criminal case. Then I'm also going to talk with you briefly about conspiracy and what we call RICO, Racketeer Influence Corrupt Organizations cases, which is one of these cases is. Now here's a chart that breaks the whole thing down for you, see. So I'm not going to, you can read this for yourself, but in essence what I've got here is the name of the prosecutor, the jurisdiction, a summary of what the case is about, the nature of the charges, and the timeline, because all these cases have some sort of trial date set, and they're all supposedly going to go to trial either in late 2023, which I think is actually impossible. I don't see how the Georgia case can possibly be tried, certainly not against Trump in 2023, maybe against some defendants. But most of them are set for 2024. Well, guess what? That's an election year. And these cases could really interfere with Trump's ability to run his campaign because he will have to be in court for a lot of these proceedings, I think. So potentially this could really interfere with the Donald Trump presidential campaign, assuming he continues to push that forward, which presently he certainly does. So this is the lay of the land here. You've got a case of State of New York versus Trump brought in Manhattan. Now I'm going to go over each of these cases in detail, but basically involves allegations that he concealed illegally through falsifying business records, payments of hush money to two women who he had sexual relations with, and he didn't want that information to get out to the public, so he paid them hush money to silence them. Those are the allegations. To do that, he concealed the payments by falsifying his business records. That's the allegation. Then we have the two really significant federal cases, both called U.S. versus Trump. One of them has another defendant. They are brought by the Department of Justice Special Counsel Jack Smith, who was brought in to handle just these cases. One is in Florida, in the Southern District, and one is in the District of Columbia. The documents case, we'll go over that in detail, but basically it involves allegations that he took a lot of sensitive government documents home after his presidency ended and refused to return them. This can carry some really significant penalties because many of these documents were classified. And, he could be looking at, potentially, if he were convicted, 10 years, 20 years in prison for this. It could potentially be serious. And cases like this have been brought against other people who have stolen government documents, and they have gone to prison for a very long time. The other case involves his efforts to try to overturn the result of the 2020 election. It is charged as a conspiracy to defraud the United States, and I'll go through the details of that. It involves a bunch of efforts that he does. Now, understand he's not charged with starting the insurrection, which is a bunch of people have already gone to prison for. He's not charged with that. He's charged with a scheme to create false slates of presidential electors and some other things to try to invalidate the outcome of the election. And then the last one is the Fulton County District Attorney Fannie Willis, who has sued him, who is prosecuting him, not sued him, prosecuting him in Fulton County in Georgia. This is also part of trying to overturn the election, but this is only about what he tried to do in Georgia. Among other things, he called the Secretary of State of Georgia and tried to intimidate him into finding votes that weren't there and other things. Those are the allegations. There are 19 defendants in that case. So that's the one where some of them want to go to trial early and others want to go to trial next year. So that's going to be a very complicated case. Okay, let's take them one by one. The district attorney for Manhattan in New York has filed a case in the Supreme Court, which is a trial court. It's not like the U.S. Supreme Court. They call their trial court a Supreme Court. Don't ask me why. He was indicted by a grand jury Again, he's charged with falsifying his business records to conceal payments of hush money to two women during the campaign, an adult film star named Stormy Daniels and another woman named Karen McDougal, women that he allegedly had sexual relations with and wanted to quiet them so that they wouldn't talk to the media about it during the campaign. So the objective here allegedly was to give himself an advantage in the election, to influence the election result by concealing the truth. He's the only defendant in the case. However, his former attorney, Michael Cohen, actually pled guilty to these very same transactions and served time in prison for them. So it's set for trial in March of 2024. Now, these are some of the principles involved. Here is Alvin Bragg. He is the Manhattan District Attorney, received his law degree at Harvard University. On the right is the judge in the case, Judge Juan Merchan, former prosecutor himself. I used to call him a career prosecutor before he became a judge. Received his law degree from Hofstra University. These diagrams came from Alvin Bragg's office. They basically diagram what the case is about. They call this sometimes a catch and kill scheme. In other words, where you know bad information might come out about you, so you try to prevent it from coming out. You catch the people, you pay them off, and you kill the news. And that's what allegedly Trump was trying to do. So it's all diagrammed there. You can take a look at it. In essence, he made big hush money payments, like in the case of, $130,000, this sort of thing, creating fake businesses that didn't really exist and funneling papers through and falsifying the checks and all this sort of thing. And all these transactions were designed to conceal the fact that he was paying hush money to these two women that he allegedly had sexual relations with, so that it would not come out in the press. He was catching and killing the story, as they say, and thereby trying to influence the 2016 election. Now, his defenses in the case, his lawyers are arguing, this is a very interesting argument, that these charges can only be misdemeanors and cannot be charged as felonies. And they're arguing that it is highly unusual to charge a matter like this as a felony and is evidence of prosecutorial abuse of discretion. It's unclear. I think the misdemeanor versus felony thing is a potentially good argument for Trump. I'm not so sure that the prosecutorial abuse of discretion claim is going to be of much legal use as a defense, although it is potentially, it influences the public opinion, might influence jurors, if some juror believed that, and it could hang the jury or maybe get an acquittal by just people thinking that the case is being brought unfairly. And he does this, as you'll see, he does this in all the cases. Now, let's turn to what I think is really a pretty significant one, the documents case. This is a federal case. Special Counsel Jack Smith, again, indicted Trump. This is in the Southern District of Florida. Why? Because Trump is charged with taking these sensitive documents with him when he left office, refusing to return them, and lying about it to conceal them because he wanted to keep them even though the government wanted them back. His assistant, Waltine Nauta, who's like someone who just traveled with him all the time, is charged with helping him hide the documents and keep them away from the government, and also trying to conceal the evidence that he had them. I think there's an allegation that security camera footage was destroyed, or there was an attempt to flood the room where the cameras were with water and so forth. So, Nauta is accused with trying to help Trump with this. So, the charges are brought. They are serious, potentially serious charges, because some of these documents are quite sensitive. They're brought under something called the Espionage Act, although he's not charged with espionage. No one thinks he was committing espionage, but the Espionage Act contains some of these things about willfully retaining national defense information, obstructing justice, withholding a document, concealing a document, etc., and then making false statements about them. Now, to boil it all down, the story here is really like this. There's something called the National Archives. The National Archives is an agency of the U.S. government that, among other things, preserves the official records of the government. And, I'll get to the types of documents in a case. You'll see how they became involved. But in essence, just in summary here, just so you can understand it, from the time he left office, they spent months trying to get him to return documents that they knew he had taken with him when he left office and that he wasn't supposed to have. So in January 22, this is a year after he left office, after all this back and forth, he agreed to return a bunch of documents. So he gave them 15 boxes of records, and he claimed that was it, right, to the National Archives. Now, the officials discovered 700 pages of records in there, in these boxes, that had been marked as classified. So the National Archives and the Department of Justice began to believe that he had not turned over everything. They had other reasons to believe this, and that some of it might be classified information. So in May of 2022, they issued him a subpoena. Subpoena is an order to produce documents, in this case. They said, give us back all these documents that you still have. So his attorneys turned over 38 pages of classified documents, and then they stated, the attorneys under oath, that all the records with classified markings had been returned to the government. Okay, well, the government did not believe that. So in August of 2022, a few months later, the FBI obtained a search warrant and conducted a search of his residence in Mar-a-Lago, which is in Florida. That's why the case is brought in Florida. What did they discover? 13,000 government documents that he had not turned over. 13,000. About 100 of them were marked as classified, including some that were marked top secret and were very, very secret, things that he should not have had no right to keep. He is charged again with intentionally retaining the documents that he knew he had no right to possess and with obstructing government efforts to get them back, including lying about them. Here's Jack Smith, the prosecutor, received his law degree from Harvard. Here's the judge, Aileen Cannon, in Florida, federal judge. She has received her law degree from the University of Michigan, also an excellent law school. She was appointed to the federal bench by Donald Trump, and she is a very young federal judge. I don't know if she's the youngest, but she's certainly one of the youngest federal judges on the bench. She used to be a prosecutor too, so she seems to have pretty good experience. Although this is an unusual type of case, I don't think there are many judges who have handled cases involving these types of document charges. So I don't know that anyone is really all that experienced with them. There are some, but they don't happen that often. But just to clarify the documents, what they're after here, the only things that are a problem in this case are there are three categories of documents here. Only two of them are significant. And actually, in this case, the only thing they're really prosecuting him for is in category number 1. Although they could potentially do something on category 2, but they're mainly worried about category 1. Okay, so there's three kinds of documents. What we call agency documents or agency records. What are those? Those are documents that were generated by a federal agency, such as the CIA, the National Security Agency, the FBI, any federal agency. These documents belong to the federal government and specifically to the agency that created them. No government official, president, or anyone else may take personal possession of these documents. Why? Because they belong to the federal government. It's very clear. Now, some of them have classification markings on them, which are designed to restrict who can see them. Secret, top secret, etc. Taking classified documents, taking any of these documents can be a crime, but taking classified documents has potentially very serious criminal penalties associated with it. Second type of document is what are called presidential records. And this is originally what the National Archives was after. These are the records of the presidency. We have a law that was passed in 1978, the Presidential Records Act of 1978. All the records of a presidency, including memos and other documents created by the president pertaining to his office while in office, belong to the U.S. government by statute. And they are kept in the U.S. National Archives and for future reference, so that we, the public, are entitled to see the full record of the presidency. The president, when he leaves office, or she someday leaves office, cannot take the documents away. They go to the National Archives. Every president understands that. Trump disagrees with all this. He thinks he can take whatever he wants. The third type, which he can keep, are personal documents. So, maybe sometimes presidents are keeping notes for their autobiography, that sort of thing, their own personal records. They are certainly entitled to take that, but they're not entitled to take agency documents that are generated by the federal agencies. The only reason he sees that is because it's his job. Some of these are classified, which makes them even more restricted. And then presidential records, which go to the National Archives. It's pretty simple. Now, what are Trump's defenses? It is not completely clear because he has changed lawyers on this case, and it's not clear exactly what the strategy is going to be. Not clear to me, not clear to anyone yet. However, he is focusing very heavily on prosecutorial misconduct and bias. I really don't see how that turns into a legal defense. However, I'll show you, there is a provision of the law that he might be able to use that in. I'll show you that in a minute. Based on the idea that the judge is a Trump appointee, and she has already shown a certain hostility toward the prosecution in this case, like, why are you doing this? What are your motives, etc. Now, the other aspect of this is in media appearances and in rallies, Trump has constantly said that all the documents he took are his, and that if they were classified, he declassified them simply by thinking about it. In other words, that there's no record that he declassified these documents. He just says, well, I thought about declassifying them, and if I think about that, then they're declassified. I'll tell you, no one's ever made that argument before, so I don't know how that's going to fare. The problem here is that the charges involving these agency documents, CIA, etc., and other agencies, by law, they clearly do not belong to an outgoing president, so I don't understand how this is going to be an argument for him, classified or no. Even if they're not classified, they're still not his. So this is going to be a very hard case for him to defend. Now, what could he do? There is a thing called Rule 50 of the Federal Rules of Criminal Procedure, which is a procedure, a rule by which a judge can enter a judgment in a criminal case before the jury gets the case. In other words, the judge can decide the case and take it away from the jury if they find that a reasonable jury could not have a valid reason to decide the case any other way. So theoretically, this judge, Judge Cannon, could potentially, if she wanted, say, okay, I don't think that any reasonable jury should be able to find you guilty, so I'm going to find you not guilty. And that can happen. It has happened in other cases. Rarely. It is a rare occurrence. It has been done for situations where there was serious law enforcement or prosecutorial misconduct. So basically, as a matter of justice, a judge could conceivably do that. I just throw that out as a possibility. There's been speculation about it. I have no reason to believe that the judge would actually do this, but it is a thing that has been, tossed out there. It is in the law. I don't know that she would ever do such a thing, but again, possible, theoretically. Now, here's the one that I think is by far the most serious case. This is the conspiracy to overturn the 2020 election. Again, this is Jack Smith, the same special counsel, who indicted Trump in the D.C. Circuit Court, and the District Court for the District of Columbia, for trying to overturn the 2020 election result. There are 6 unindicted co-conspirators. They have not been charged, but they could be. I'll tell you who they are in a minute. Now, these are really serious charges. And potentially, Trump or any other of these co-conspirators, if they are charged, could go to prison for many years, decades for this. So you have charges of conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, which is the counting of the electoral votes, the official counting in Congress on January 6, 2021, obstruction of an attempt to obstruct that proceeding, and conspiracy against rights, meaning conspiracy to deprive the country, the voters, of the right to choose their president. That is currently set for trial in March of 2024. Let's talk about conspiracy. What is conspiracy? Because this is clearly a conspiracy case. If 2 or more people agree to commit a crime, and then any one of them, or more of them, but even one of them, commits any overt act or acts in furtherance of committing the crime, they are all guilty of the crime of conspiracy, even if they don't commit the ultimate target crime. Conspiracy is a separate crime. And the overt acts don't need to be crimes. In fact, usually they aren't. They're just acts in furtherance of the crime that they're trying to commit. I'll give you an example in just a minute, but understand they don't need to actually commit the target crime. They just have to agree to commit it and then act on the agreement, and boom, they're guilty of conspiracy. So conspiracy is a separate crime with its own punishment that can be charged in addition to the crime they conspired to commit. So in this case, they're charged with attempt to obstruct the official proceeding. Well, they're also charged with conspiracy to obstruct the proceeding. And those are separate crimes. Now, so here's an example. 3 people sit in a house, right? They're sitting around the table, they have a conversation, and they say, let's rob a bank. They all agree that they're going to rob the bank down the street. How are they going to do it? They agree they're going to wear ski masks, and they're going to use a rented car and a borrowed gun. There's the agreement. Boom. Step number 1. Do you have an agreement? Yes. Agreement. Now, all that has to happen at this point is any one of them takes any overt act toward completing the conspiracy, and they're to committing the bank robbery, and they're all guilty of conspiracy. Let's say the police have an eavesdropping device to overhear the conversation. And so they know about the agreement, right? One of the conspirators then goes to a sporting goods store and buys 3 ski masks. Is that a crime? Nope. But is it an overt act? Yes. Another one rents a car. Crime? No. Overt act? Yes. The third one borrows a gun. Is that a crime? No. But is it an overt act in furtherance of the conspiracy? Yes, it is. The police arrest them before they can rob the bank, charge them all with conspiracy to rob the bank, and boom, they're all potentially guilty of conspiracy to rob the bank. Now, if they had robbed the bank, they could have been charged with that as well as with the conspiracy. So this is the sort of thing here. There was a plan. The allegation is that there was a plan, a plot to subvert the election and to give Trump a win for the election that he didn't earn. And that conspiracy did not work. They did not ultimately, take over the country and give him another 4 years in office. Doesn't matter. They had tried to, which is an attempt, and they conspired to, which is a crime. Now that's the theory of the prosecution. We'll have to see if a jury or judge agree with this, but that's the theory of the case. So let's quickly summarize the facts, as I've done with these others. So Biden defeated Trump in the 2020 election by a substantial margin. He won by over 4 percentage points in the popular vote, Biden did, and he won by a lot in the Electoral College, 306 to 232. Easy win. Trump refused to accept that he had lost, and he said the election was rigged, and he's still saying that. And he and his associates filed 63 lawsuits to making that claim, and they lost all of them. And so, they never were able to produce any evidence whatsoever that the election was rigged. So I'm going to state to you as a matter of fact that the election was not rigged, not in any state at all. There was no substantial election fraud in any state in the country, and anyone who says there was has not looked at the evidence, because there wasn't. And Trump brought these 63 lawsuits in states that are controlled by Republicans. He brought them in front of Republican judges and Democratic judges and old judges and young judges, and he lost every single case because they could not produce any credible evidence that there was anything wrong. So they went all across the country, and they've convinced 30-40% of the public that the election was stolen, and it is a complete falsehood in every respect. Total 100% falsehood. Trump lost the election fair and square, and that's that. But then after he lost all these lawsuits, then he and his associates developed a plan, the indictment alleges, to stop the congressional certification of the electoral votes on January 6, 2021, and somehow throw the election to Trump. Now, this failed. But it involves something called fake electors. First step was they asked governors and secretaries of state in a whole bunch of states, Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, Wisconsin. They said to the governors and secretaries of state, if they were Republicans, don't certify the popular vote result. Don't. Just say, that Trump won. They continued to claim that there was non-existent voter fraud to encourage the state legislatures and the governors to set aside the popular vote in their states, and instead to appoint, regardless of the vote, to appoint a slate of pro-Trump electors from each state. And the complaint or the indictment says that this evolved over time from a legal strategy to preserve the defendant's right. Well, this is fair. I mean, those lawsuits, he has a right to file those lawsuits, and the complaint acknowledges that. That was okay. You can file lawsuits, but if you lose, then you can't conspire to overturn the election result, and that's what he says the prosecutors say it did. They tried to subvert the functioning of the federal government by stopping Biden's electors' votes from being counted on January 6 and certified as required by the Constitution and federal law. How did they do this? They created slates of fake electors. The electors are the people chosen by the popular vote. If Illinois, if a state has, let's say, let's just take any state. A state has, let's say, 4 electors or 5 electors or 20 electors, which is the total number of their members of the House and the Senate. All states have 2 senators, so you add to that the number of their members of the House. That's the number of presidential electors they get, right? So they created, if you win the state of Illinois in the popular vote, you get all electors for Biden, and those electoral votes are the ones that determine the election outcome. Now, what happened here was they created lists of fake electors, just Trump supporters, who were not entitled, because these were states that Trump lost. So they don't get to have Trump electors. They're all Biden electors. Those are the official real electors chosen by the state legislature. So first they tried to get the state legislatures to certify the fake electors. And even though these states were controlled by Republicans, those Republican legislators refused to go along with this scheme because they knew it was wrong. So give these Republican legislators some credit, because they stood up to this very powerful Republican and his organization and said, no, Biden won this state. That's what happened in Georgia and other states. The governor's a Republican, the legislature's Republican. They said, no, we're not going to do this. Biden won the state. That's the way it goes. Sorry, you lost. So then, after that plan failed, Trump and his associates decided to disrupt the official counting of the electoral votes on January 6th in front of Congress, in the hope of having enough objections raised by Republican members of Congress and enough disruption, and as you know, there was an insurrection that they were involved with as well, to try to stop the counting of the votes, to throw the election into the Republican-controlled House of Representatives. Because if, the way our Constitution works, without going into all the details, but basically, if the counting of the electoral votes does not produce a clear outcome, a winner, that's what they were trying to prevent, then the House of Representatives decides the election, with each state delegation having one vote. Well, the Republicans controlled more state delegations than the Democrats. If he could have had the election decided by the House of Representatives, he could have been elected. So that was the plan here, to disrupt the official counting of the electoral votes, raise questions, disrupt it. There was also, as you know, this massive insurrection in which they stormed the building and tried to find the electoral votes and steal them and run away with them. That would have potentially thrown the whole election into the House. That was the plan. It failed. Now, again, Trump's not charged with starting the insurrection, but that's another story, and we'll see what becomes of that down the road, if anything, maybe nothing. I mentioned the unindicted co-conspirators. These are the people who helped him try to do this. These were all attorneys. Rudolph Giuliani, John Eastman, who's a law professor and an attorney. Sidney Powell, a trial attorney. Jeffrey Clark, who was was an attorney in the Department of Justice. He tried to mobilize support in the DOJ for the scheme and failed. Kenneth Chesebro, he drafted a memo on the fake elector scheme and how it would work. Boris Epshteyn, who is an attorney and a political consultant. All these people were involved in all this. They have not been charged, and I think one issue here. I mean, they are the unindicted co-conspirators. They are not named in the indictment, but it is obvious, and news media people have clearly identified them. It is very clear who they were from the things that they said. You can match the allegations against them in the indictment with things that they actually said in public, so you can figure out who they are. That's who they are. I put Trump's picture up here because it's the same prosecutor, Jack Smith. The judge is Tanya Chutkan. She's a lawyer she was born in Jamaica. She received her law degree at the University of Pennsylvania. She's a federal district court judge. Now, Trump's going to have defenses in this case. He is going to argue that everything he said about the 2020 election was protected by the First Amendment, that it was all political speech, that everything he said about the electors, about the voters, about the votes, about the electoral, everything that he said was protected by the First Amendment. And the indictment acknowledges that. They say, well, that would be protected if that's all he did. But if he took actions that amounted to fraud, trying to defraud the public, that is a crime. So they're focusing on the things that he did in conjunction with his other co-conspirators, and not just his beliefs. I mean, he's entitled to claim that he won, even if he thinks he didn't. It doesn't matter. So another ace in the hole he has, apart from a legal defense, was if he wins the presidency in 2024, he would then have three options for dealing with these two federal cases. By the way, not going to work with the state cases. I'll tell you about more about that later. But basically, he could order his new attorney general to fire Jack Smith and dismiss both the federal cases, both of them, the documents case and the election interference case. Or, if he's already been convicted, he could pardon himself. It is not clear if this is illegal because it has never been done. He could also invoke the 25th Amendment and go into the hospital and say, I'm receiving general anesthesia, and have the vice president pardon him while the vice president is acting as president pursuant to the 25th Amendment. So he's got a lot of options. If he wins his long shot here is he doesn't need a legal defense if he wins the presidency. That is true of the federal cases. It is not true of the state cases. So now here's the final one, the state of Georgia versus Trump. This is kind of amazing because a local district attorney, Fannie Willis, indicted him and 18 other defendants with trying to overturn the election just in the state of Georgia. And they've got some really interesting evidence. I mean, they've got a recording, an hour-long recording of Trump on the phone with the Secretary of State, his name is Raffensperger, basically telling him, listen, if you don't find me the votes I need to win this state, you could be committing a crime. You could be in serious trouble. So they've got some really interesting evidence. And again, Trump's going to say, First Amendment. I have a right to say what I want. That's political speech. It's protected by the First Amendment. And this is what's called a RICO case. I'll explain what that means in a minute. It is a state law, but it is modeled on a federal law called RICO, Racketeer Influence Corrupt Organizations Act. Now, Fannie Willis wants to try all these 19 defendants together, but the defendants are all going in different directions, and she's never going to be able to do that. The case is going to be very complex. Some of them want to go to trial in October of this year. Others want a later trial. And some of them want the case removed to federal court. So what does that mean? When a case is filed in state court, civil or criminal, sometimes it can be removed to federal court. It's done all the time in civil cases where where you have citizens of different states suing each other, this sort of thing, very common. It can occasionally be done in a certain type of criminal case, and that's what we have here, where an officer acting under that person's office in the United States, like a president, a chief of staff, or whatever, is facing criminal charges for or relating to any act done under color of their office. And they're being prosecuted in a state for doing their job as a federal officer. And they have a colorable, meaning a reasonable, federal defense. Now, Mark Meadows is one of the defendants in this case. He was Trump's chief of staff. He wants to remove it to federal court. Now, this could get complicated real fast because it doesn't mean a federal judge would decide it. It doesn't mean federal prosecutors would be involved. They wouldn't. If it gets moved to federal court, the state prosecutor, Fannie Willis, continues to handle it in federal court. And the state laws are applied in federal court by the federal judge. But the judge would be a federal district court judge. And the jury might be better for Trump, maybe, because it would come from the entire federal judicial district in that area of Georgia, which is much bigger than the county where the DA filed it. Right now, you'd get a jury from that county. So he'd have a broader jury pool, maybe better for him, who knows, and a federal judge. Maybe he could get someone he appointed. Who knows? Nobody knows. This is the current judge in the case, Scott McAfee. Went to law school at the University of Georgia. There's Fannie Willis, law degree from Emory University, both excellent law schools. What is this RICO thing? Well, passed in 1970, the Racketeer Influenced and Corrupt Organizations Act, brand new criminal statute that was aimed to make it easier to prosecute organized crime cases. Criminal organizations like the mafia, that sort of thing, sometimes, or gangs of any sort, sometimes infiltrate and take over legitimate businesses or labor organizations like unions, and they basically turn a business or a union into a criminal enterprise. So RICO allows prosecutors to prove this. They can take a whole bunch of crimes, maybe each one a separate conspiracy, that were not related on the surface, and show that they're part of a pattern that can be prosecuted as racketeering that is being conducted by an organization, so that participants can be punished for the underlying crimes and also for the RICO violation, for racketeering. Georgia has its own RICO statute, and Fannie Willis has done this before, prosecuted crimes basically as an organized crime case. She knows what she's doing, and we'll just have to see. She's basically saying these Trump and his people were like a criminal organization that essentially took over the campaign and the presidency and started committing crimes. So that's a very interesting and imaginative way to go about it. Now, what are his defenses? Well, prosecutorial misconduct again. I don't see how that's going to be a defense, but he's going to try it. He will also say he was exercising his freedom of speech rights, and he absolutely will say that, and that's, potentially a valid defense. We'll have to see whether the jury believes it or not. He has also said there was no crime committed. He didn't do anything wrong. He had he calls it a perfect phone call. One thing here is that the complexity of the charges and the many defendants could turn this case into a logistical nightmare for a local prosecutor's office and really suck up their resources. So we'll just have to see how that goes. That could help him in the sense that it just becomes such an unwieldy case that it's hard for the prosecutors to manage. On the other hand, they knew they were getting into this, so presumably they thought about that. Now, I also want to talk to you about, those are the criminal cases. Now, there's also a civil fraud case. This is not talked about much in the news media, but this is a really significant case, in my opinion. The Attorney General for the state of New York, Letitia James, has sued Trump, his family members, and his business entities, the Trump Organization and all their little corporations, for civil fraud. If he loses this case, she wants to have him prohibited from doing business in the state of New York. And she wants to have his corporations dissolved, put out of existence. So we sometimes call that the corporate death penalty. This case could be tried in really soon, potentially like within a month. He's trying to stop the trial right now. He actually filed a lawsuit against the judge, which is highly unusual. And so things have been slowed down. He's trying desperately to slow this case down because it's racing toward trial. The standard in this case is a preponderance of the evidence. It's a civil case. All she has to do is prove it's more likely than not that he did this. And she's saying basically what's going on here. I'll explain to you what it's about. These are the charges. That he has persistently and repeatedly lied about the value of his properties in the state of New York for decades. They claim that he is doing this to defraud banks and insurance companies and to cheat the government out of taxes. So, for example, let's say he wants to borrow money using one of his properties for collateral. Oh, he says that property is worth an enormous amount of money, more than it's really worth. But when he's going to be taxed on the value of that very same property, oh, it's worth almost nothing. It's almost valueless. It's worth a fraction of what he said. So you see, they've got him in a number of cases where he said the same property was worth a lot of money or very little money. So clearly he's misrepresenting somewhere. That's the argument. And that's the kind of fraud that they're talking about. Now, his possible defenses are that he's blaming his son. In his deposition, which only took place recently, they asked him, are you the ultimate decision maker in the Trump businesses? And of course, he has always claimed to be, that they're his businesses and I'm the big shot, I make the decisions. But he said, no, not really. I've been too busy. He said, my son Eric is much more involved with it than I am. I've been doing other things. He said, I guess you in some major final decisions, but I've been much less involved in it than over the last 5 years. Anyway, point is, he's trying to say his son Eric was the major decision maker. Well, his son Eric is named in the lawsuit as well. So it sounds like he might be blaming his son for making a lot of these decisions, saying, I didn't know anything about it. Now, lastly, let's talk briefly about the defamation case. E. Jean Carroll is a journalist, and she says that in 1995, Trump sexually assaulted her. Now, she did not sue him for that at the time, but it came out publicly that she had said these things about him. And he accused her very publicly of making it all up. So she sued him for defamation. She said, you're slandering me. And she won. The jury believed that she was telling the truth about the fact that he sexually assaulted her, and that Trump was lying when he said that he knew that he had sexually assaulted her, although he was not convicted of rape. This is not a criminal case. This is just a civil case for defamation. She sued him for defamation and won a $5 million verdict. Boom. So what happens? He then proceeds to go on TV and go to rallies and repeat, after losing the case, to repeat the very same defamatory remarks. She's a liar. I never met her. I don't know her. There's actually pictures of him standing next to her in photographs from the time. And he says he never met her. So she just expanded, went back to the judge and said, Judge, I want to expand my lawsuit for defamation, which I've already won, to include what he said after the trial. And the judge said she could do that, and ruled that Trump had already, well, he ruled against Trump in a summary judgment motion on liability. So that means that there's going to be a trial, and it's only going to be about how much money Trump has to pay in damages, because he's already lost the case on liability. I mean, he'd already lost it once, and now he's lost it again, and so he owes $5 million, and now she wants another 10. So I don't know what's going to happen with this. Now he presumably can pay a judgment like this. This is not like the previous civil case where he could lose his businesses, which is a really serious matter. That's a very, very serious matter. But this is still, I mean, it's millions of dollars. So that's not nothing, but presumably a man of his wealth would, be able to pay judgments like this. And then, of course, he could appeal. So let me just wrap this up, okay? What are the stakes for Trump? The two federal cases are the really serious ones. They carry potentially decades in prison as likely sentences. And I say this because the federal sentencing guidelines are pretty strict. It's not all that discretionary. There are sentences that judges are supposed to impose for certain offenses. So if he's convicted of certain crimes, there are certain numbers of years, and there are a lot of years, especially for the documents case. Well, both of them. I mean, the Espionage Act is very serious. The defrauding the U.S., both of these, I shouldn't say one's better, more serious than the other. Both the documents case and the election interference case could result in decades in prison, and they're separate crimes. So, very likely if he were convicted on both of them, he'd serve sentences consecutively, serve sentence on one, serve sentence on another. On the other hand, if he gets to be, president again, maybe he'll just terminate both those cases. Now, the New York criminal case, I don't think the one about the falsifying his business records to do the hush money payoffs, I don't think that would be likely to lead to a long prison sentence. Michael Cohen, I don't remember exactly what his sentence was, but it wasn't a long sentence, and a lot of it he served in home confinement. It's kind of a white-collar crime. They usually don't, charge these things as felonies anyway. But he can't get pardoned for it. The pardon would have to come from the governor of New York, who's a Democrat, and I think it's almost inconceivable he would be pardoned by him. And he can't, since they're not federal cases, no federal official can pardon him. The Georgia case could result in a state prison term. It's potentially serious. But, and there, can he get pardoned? Well, there, the governor does not have the sole pardon power. The governor is a Republican, but pardons come from a commission. Now, he does appoint the members of the commission, the governor does, but it's just not clear whether he would get a pardon or not, because it would have to go through a multi-member commission. As I said, in terms of stakes, in my opinion, what people are not noticing is the seriousness of this New York civil fraud case, which has the potential to ruin him financially. The vast majority of his income comes from the state of New York. That's where most of his income properties are, apartment buildings and other things, condo buildings and whatnot. They're in New York. If he is put out of business in New York, he loses the bulk of his business. If his corporations are dissolved, he's in a world of hurt. So there you go. That's the lay of the land with these cases. I think that interestingly they are unfolding so quickly that I may do a supplemental video on this at the end of the semester to update where we stand if significant events have happened. So I hope this has been useful for you, and I hope you enjoyed it.